right. Well, welcome to episode 1 of Triple P, the Parallel Proceedings podcast. My name is Kevin Mullendorf. I'm a white-collar and securities enforcement defense attorney at Wiley Ryan here in Washington, D.C. The goal of the podcast is to highlight issues in the investigation and prosecution of white-collar matters, with a focus on the overlap between SEC and criminal prosecutions. We're not going to just touch on SEC. We'll cover other financial market regulators like the CFTC, as well as any area where individuals and entities find themselves facing the potential of simultaneous government investigations. We're going to review the recent cases and resolutions and see what that tells us about defending these matters. And we're going to have some guests to talk about cases they've investigated, prosecuted, and defended. We're going to have the law, the order, and all the folks like me who have done both and find ourselves wondering how to navigate our clients through this very sticky situation. A little background about me. I'm a former SEC enforcement attorney. I spent 6 years as a federal prosecutor in the DOJ Fraud Section's Securities and Financial Fraud Unit, which has since been rebranded as the MIMFU. Most recently, I was the acting inspector general at WMATA, our trains here in Washington, D.C. I returned to Wiley, where I practice white-collar criminal defense and lead the securities enforcement practice. I've been here about 8 years, and I've spent most of the last 8 years representing individuals, executives, and companies under investigation by civil and criminal authorities. So a lot of insider trading, FCPA, accounting fraud, and more recently, some crypto cases. I'm also an adjunct professor at Georgetown University, where for the last 10 years, we've taught the issues we're going to talk about in this podcast to LLM students. So I've spent most of my legal career prosecuting, defending, and teaching about parallel proceedings. But until you've felt yourself the immense pressure that these proceedings can put on a person, it's really hard to convey. So for example, imagine you're trying to advise someone who wants to tell the SEC that they didn't do it. You know they're innocent. They know they're innocent, but the risk of putting them under oath in SEC testimony can be so great that they might have to sit silently while the SEC accuses them of horrible absence of professional, legal, and ethical judgment. And that's where we find ourselves. So let's talk about what is a parallel proceeding. What does that really mean? It's overlapping civil, criminal, or administrative investigations or prosecutions. Or as the police, the band, not law enforcement, so aptly reminded us in the great album Synchronicity, it's like being caught between Scylla and Charybdis. But unlike the six-headed monster Scylla that eats men and the whirlpool Charybdis that sinks ships, DOJ and SEC are not mythical beasts, but like Odysseus, individuals have to figure out how to navigate between them. So why are we here? Why are DOJ and SEC allowed to do this? Well, since this is the inaugural Triple P, let's start off talking about the why and the how. Why does the government do this to people? And isn't it a waste of resources for multiple government agencies to investigate the same thing? And most importantly, how the heck is this fair? Well, there have been parallel proceedings for a very long time, most significantly in different regulatory spaces. For starters, as I mentioned, DOJ and SEC. And the reason is they vindicate different interests. SEC obviously has its investor protection mission, and DOJ does too, in a way. But really, they're there to enforce the criminal laws. And if you accept the fact that they have different missions, then what you see is that from their point of view, it may be more efficient for the government to simultaneously investigate the civil and criminal aspects of some behavior. And it's certainly more efficient when, as a result of the different rules that apply to SEC civil and DOJ criminal actions, which we're going to talk about later, these parallel proceedings can force a defendant to stay silent and give the SEC an enormous leg up in their civil action, sailing towards Scylla and losing a few men rather than the whole ship in a whirlpool. Or at least that's how Homer laid it out for Odysseus. So that's the efficiency answer. But given the bind it puts defendants in, the rock and the hard place, how is that even fair? Well, it's fair because the courts say it's fair. But again, how many of them have personally faced this problem? The case that frequently gets cited here is from the D.C. Circuit. It's pretty old, or pretty old as these things go, from 1980. It's called SEC versus Dresser Industries. Ironically, it's a subpoena enforcement case. It isn't even really about parallel proceedings in the sense of, is it fair? But the D.C. Circuit gets into a lengthy discussion in this subpoena enforcement action about the fairness and the reasons for parallel proceedings. And so it's one of the most cited cases in this area. So The SEC versus Dresser Industries case is what the D.C. Circuit euphemistically calls about questionable foreign payments. It was an FCPA case back when the FCPA was relatively new. And a subpoena enforcement action, for those of you who don't know, is, the SEC has the ability to issue subpoenas and compel people to produce documents or testify. And it's not limited to just public companies or their employees. The SEC can do that to anyone that they can get jurisdiction over. And if you say no to the SEC enough, or you just ignore them, they will eventually go to federal district court and ask for an order compelling you to comply with their subpoena. And that's what happened in Dresser Industries. In a nutshell, there's a whole lot more background we're not going to get into. We could do a whole nother podcast on the strategy of dealing with this, and maybe we will. But speaking of euphemisms, this case starts when the SEC has what they're calling in 1974 a voluntary disclosure program. You can voluntarily disclose your problematic foreign payments, or as we like to say, turn yourselves in. And if you do so, while it doesn't insulate you from SEC enforcement actions, it was supposed to get you a lesser SEC penalty. And sitting here 40 years later, this all sounds pretty familiar to people who operate in this space. The funny thing about back then was simultaneously 2 SEC attorneys were participating in a DOJ transnational payments task force. This is something we see a lot in these parallel proceedings, is both enforcement agencies issuing subpoenas simultaneously. So Dresser refused to comply with the SEC subpoena, and there's a lot more to the background on Dresser suing the SEC and things like that. But anyway, this gets us to what the D.C. Circuit said about parallel proceedings and answering the question, how is this fair? They said, in the absence of substantial prejudice to the rights of the parties involved, such parallel proceedings are unobjectionable under our jurisprudence. And then in looking at the why, the court cited the 33 and the 34 Act, which, quote, explicitly empower the SEC to investigate possible infractions of the securities laws with a view to both civil and criminal enforcement, and to transmit the fruits of its investigation to justice in the event of potential criminal proceedings. So let's pause for a second and think about that. So the SEC, a civil enforcement agency, was set up. I mean, the 33 and the 34 Acts, are the sort of the core acts, and some of the other core securities laws actually also have referral provisions in them, with this explicit point that SEC would involve DOJ in these cases at some point. And that's something in these parallel proceedings you always have to keep in the back of your mind. And we're going to talk about that in our strategy podcast. But the court goes on. If the SEC suspects that a company has violated the securities laws, it must be able to respond quickly. It must be able to obtain relevant information concerning the alleged violation and to seek prompt judicial redress if necessary. Similarly, justice must act quickly if it suspects that the laws have been broken. Grand jury investigations take time, as do criminal prosecutions. If justice moves too slowly, the statute of limitations may run, witnesses may die or move away, memories may fade, or enforcement resources may be diverted. So there you have it. And almost exactly 44 years later this month, nobody questions whether DOJ and SEC working together is fair, except in the rare instances where they cross that line, where the parallel investigations merge, causing the substantial prejudice that the Dresser Court talked about. And we're going to investigate those cases as we proceed through the podcast series. So now we know the why. But why do we care? Why are we going to talk about this in this podcast? Well, it creates a unique pressure on people and entities in these parallel investigations. Using our hypo from a few minutes ago, you can see that together the agencies can erode, in a perfectly legal way, the benefits of the Fifth Amendment. So, for example, the SEC thinks you've committed insider trading. And anyone who's done this knows that when the SEC thinks you've committed insider trading, they really think you did it. Obviously, you want to explain to the SEC why you're innocent. And of course, the SEC would love for you to do that explaining on the record and under oath. It helps them in their civil case against you. It locks you into your story. But at least you get the shot to defend yourself. Or maybe you decide not to do it under oath and you give a proffer. But even here, as we'll discuss, those proffer agreements only provide you so much protection. But if you do testify, if you choose to explain to the SEC why you are innocent, like a shark circling below you that you can't see, DOJ is waiting. Waiting for you to lock yourself into a story, waiting for you to do it under oath. So what does your lawyer advise you? He advises you to do the smart thing. He says, don't testify. You can take 5 and live to fight another day. Except that you can't. Because the six-headed monster of the SEC, if you take 5, assumes that you did it. And there's a metaphysical certainty that they think that means you did it. And the enforcement staff will tell the commission that you took 5 and that they should sue you and publicly accuse you of fraud. And they will. Which, by the way, will cost you your job. All because you chose to invoke a constitutional right. So you choose to sail towards Scylla, lose a few men, lose your job, but you didn't get sucked into the whirlpool of Charybdis. So it's quite a sticky wicket. But that's the background of why we're here. And in later podcasts, we're going to talk about how you navigate this problem, because there are ways. All right. So that's the background of parallel proceedings, why we want to do this podcast, what we want to talk about. We're going to talk about all sorts of cases where this comes up, and we're going to have guests talk about how they get their clients through it, things they've done. We'll even have some government folks, I hope, on. But let's talk about some news from the parallel universe. I mentioned proffers a few minutes ago. So an interesting thing came up in an email I got. I heard that there's an office, we don't know which office it is, a DOJ office, who's changed their proffer agreements and is demanding that individuals and their attorneys who proffer to DOJ agree in writing not to talk about what was discussed during the proffer with anyone. I think the general reaction I heard from other defense attorneys is that this is wrong on so many levels. It's almost unbelievable that DOJ would do this. It attempts to restrict an attorney's ability to represent their client. And I think it probably violates Rule 3.4F of the model rules, which says a lawyer shall not request a person other than a client to refrain from voluntarily giving relevant information to another party. I'd love to hear from folks about this, and I'd love to get other people's thoughts on this. Can DOJ tell you and your lawyer you can't share information with other people? They can certainly caution you against obstructing an investigation and suggest it's not in your interest to share information, but making you sign an agreement not to do it seems to go too far. You know, doesn't that interfere with joint defense agreements? Doesn't that interfere with a lawyer's ability to represent you by investigating what they learn in the proffer session? So the next news item, which is too big to be covered here in this podcast, is, of course, DOJ announced its whistleblower award pilot program. After a little bit of a delay, they laid out the rules. I'd be remiss in mentioning that when I was the Inspector General at WMATA, we instituted our own whistleblower award pilot program months before DOJ. But anyway, obviously the SEC's program has been tremendously successful and has spawned a lot of parallel proceedings. DOJ's program is aimed at matters that don't necessarily involve SEC, so it may not generate more parallel proceedings with the SEC, but time will tell. All right, so that's it for today's Parallel Proceedings podcast. Triple P. Send us any questions, comments, concerns. If we choose to read and answer your question, we will send you some Triple P swag. You can email me directly at kmullendorf@wiley.law. You can find me on LinkedIn. So thanks for joining. Hopefully this was worth your 10 minutes. In the next episode, barring some late-breaking white-collar news, we're going to take a deeper look at the mechanics of how DOJ and SEC work together and how we as defense lawyers address those issues. Or to bring us back to the police album Synchronicity, how to navigate clients between the devil and the deep blue sea. Until next time, again, I'm Kevin Mullendorf, and you can find me on LinkedIn or at wiley.law. Thank you.